Hey everyone, my name is Vojchehoske and welcome to Nebraska Landlords YouTube channel, where my mission is simple. That's to enhance the landlord-tenant relationship through education. Today's video is sponsored by Performance Property Management. Hey, if you're just simply tired and you're tired of being a landlord and it's time to turn it over to a property management company, give Performance Property Management a call. Ask for John. Contact information is right here. In today's video, we are continuing our series on simplifying the Nebraska Landlord Tenant Act. Today, we're going to cover Nebraska Revised Statute 76-14-13. This deals with notices. I want to talk about what a notice is and how do we properly and legally deliver notice, and it's in 76-14-13. So first of all, this statute outlines the requirements for a tenant to deliver notice to their landlord or property manager, and it also establishes when the landlord needs to send a notice to their tenant. Now let's talk about the requirements first for the tenant to deliver notice to the landlord. The statute says the notice is delivered at the place of business of the landlord through which the rental agreement was made, or at any place held out by him as a place for receipt of communication. A couple of things we need to know about this. Number one is, landlords, make sure that you have in your rental agreement the address in which the tenant is to deliver their notice. If you don't have that in your current lease agreement, and it's a fixed expiration or a month-to-month, either way it doesn't matter, what I would recommend is that you send a 30-day notice to your tenant with the address, the physical address in which the tenant is to deliver the notice to you. If it's a fixed expiration lease agreement, giving them a 30-day notice for this is not a substantial change to the current lease agreement, so it's perfectly legal to do that. I mean, landlords move, property management companies move their offices, and this happens all the time. Just give a 30-day notice to your tenant that where they are to now deliver these notices if you don't currently have it in your rental agreement. Number two is, if you don't have anything in your lease agreement or you have not notified them where they are to deliver a physical address which they are to deliver the notice, then it's assumed under the statute that the tenant only needs to deliver the notice to where you and the tenant sign the rental agreement. So if it was at McDonald's where you both met and you had a cheeseburger and you both signed the lease agreement, under the statute, that's where that tenant is required to deliver the notice. The other thing is, I know a lot of landlords put in their rental agreements that the tenant is to text the notice, they are to email the notice, or anything like that. I would really, really caution you against that. Depending on the judge that you draw, the judge may not, I've seen judges throw it out. They will say that is not consistent with the statute. Others accept it, others don't. So you're running the risk of which judge that you draw. Number two is, you're also basically opening yourself up to a reasonable accommodation request under fair housing. That's for a different video. Best practice is, from a risk management point of view, is to have a physical postal address for the tenant to deliver all notices. All right, let's talk about the notice requirement for landlords to tenants. What does the statute say? It says notice is delivered when it's delivered in hand to the tenant or mailed to him at the place held out by him as the place for receipt of communication, or absent such designation, his last known residence. So there's a couple of things here with this statutory provision. Number one is, the landlord is perfectly okay to hand deliver the notice to the tenant. That is not the preferred method of delivery, and there are several reasons. Number one, there are safety issues. Number two, there are issues of where I've seen this, where you knock on the door, you hand the notice to the person that answered the door. Well, the person that answered the door was actually just a guest. The guest never gave it to the tenant. The tenant shows up in court and says, I never received it. In fact, she was the one that was babysitting. She delivered, or she received the notice and forgot to give it to me. I have seen legal aid attorneys use this technique to postpone evictions. And if you get a sympathetic judge, you're going to have to start all over again. The second method of delivery is by mail. And if you read the statute, it doesn't say Certified mail, registered mail, mail that requires the tenant's signature? No, it just says mail, meaning first-class mail. Folks, don't make this mistake. Use first-class mail. That is the preferred method of delivery. Send it to the rental property's address. There is no statutory requirement for proof that the tenant received the notice. There is none. I've had tenants call me and say, well, I never received it. And it doesn't matter. The statute only calls for the landlord to drop it in the mail, first-class mail. That's it. Now, here's the problem with certified mail, registered mail, those type of mail deliveries that require the tenant's signatures. It's contrary to what's required under the statute. It is legal, but it's contrary. So what happens is you are voluntarily agreeing to a more strict standard of delivery than is required under the statute. So in this case, the tenant is able to go into court and say, I never went down and signed for it. I never received it. And almost 100% of the time, the judge is going to throw it out because you voluntarily agreed to a stricter standard of service when you really didn't need to. So then you're going to have to start the whole process over. That's why we don't do certified, registered mail or those type of delivery methods that require a signature. Then the statute goes on to say, in absence of such designated place of delivery to the last known place of residence, which is the rental property address. We run into this when a tenant abandons the property, a tenant moves out and they leave their personal junk in there, their personal property. We have to send a notice under the Uniform Property Disposition Act to the tenant to come and get their stuff, or we're going to do X, Y, and Z with their personal property. Those notice requirements are the same under the statute as delivering other notices like your 30-day notice, but if you can't, if the tenant is moved out, you don't know where they are, you don't have a forwarding address, then what you must do is send it to the last known address, which is the rental property. Folks, make sure that you stay in compliance with these service notices because it's always the little technicalities that when we go to court to do an eviction, our cases get thrown out when the tenant ends up getting a legal aid attorney or they have an attorney or you get a sympathetic judge and they see that you didn't do it correctly. They toss it out and make you start all over. It's those little things that cost us money. And folks, that's why it is so important to stay informed of what's going on. And the best way to do that is subscribe to the channel. Click the little circle right here. Join our email list and our Facebook page. You can do it by clicking the square right here or down below. I have links in the video description. Join our email list. So important to stay informed, guys. That's all I have in today's video. I'll see you in the next informative video.